In Clause 17, Amendment 27, Baroness Fox.
My Lords, I rise to move Amendments 27, 29, 62 and 75 that relate to debt recovery and concerns about the proportionality, even constitutionality, of the Bill's use of direct deduction orders. And many thanks to the noble Lord Palmer of Charles Hill for his support in this endeavour. The purpose of these amendments and a later group starting Amendment 102 is to transfer the powers of the Minister in Part 1, the Secretary of State in Part 2, to make direct deduction orders and deduction from earnings orders to relevant courts, whether the County Court in England and Wales or the Sheriff in Scotland. Before I look at the substance of this issue, to note that regarding Amendment 29, this addresses Clause 19(2) and Schedule 5, Paragraph 3(2), in which it is only required for the Secretary of State to believe that a person holds the bank account in question. Other provisions require such belief to be reasonable, so inserting reasonably before believes would impose a reasonableness test. Not having such test removes the balance of proper scrutiny and removes any threshold for a belief and needs to be addressed to prevent unscrupulous intrusion. Meanwhile, Amendment 62 is to probe in what circumstances orders can be restarted where it's been suspended, because I'm confused about why that's necessary. But to return to the fundamental principles at stake in Amendments 27 and 75 especially, and the broad theme, my Lords, for centuries the rule of law and the separation of powers has ensured that a person is innocent until proven guilty and cannot be punished by political diktat. The executive cannot arbitrarily take action against a person, even a debtor, in the manner that this bill gives the relevant minister. The bill allows the minister to order a bank to supply sensitive bank information for the purposes of debt recovery without either judicial oversight or individual knowledge. At our first committee, we heard from the noble Baroness Lady Finn the shocking details about how Clause 7 allows relatively junior civil servants in the Cabinet Office to apply for a warrant to enter and search premises and seize anything they have reasonable grounds to believe has been obtained in the commission of fraud. If handing police powers to civil servants wasn't chilling enough, here are powers that facilitate the state raiding bank accounts. These measures, whether it is for fraud by a person or error on the part of the state, which again in this part of the bill fails to distinguish, allows the minister to get financial information from a person's bank account and take their money without telling them or without judicial authorisation, and with the only potential recourse for the person affected to appeal after being informed that the orders have been made. This is where the section of the bill lacks clear safeguards. In this bill's previous incarnation, in the Data Protection and Digital Information Bill, the noble Baroness Lady Kidron stated that this power, or a similar power, enables the collection of highly sensitive personal data, yet comparable powers under the infamous Investigatory Powers Act are subject to rigorous safeguards: judicial authorisation, scope limits, oversight and redress mechanism. But in this bill, these measures contain few, if any, such protections. The noble Baroness Lady Chakrabarti made a similar reference, and I quote, "It is absolutely flabbergasting that there are greater checks and balances for investigating matters of national security than for investigating what could be minor benefit fraud." Just to emphasise that none of us here supports fraud against the state. It is a fraud of our fellow citizens as taxpayers, and it's completely unacceptable. But I want to tackle this without compromising on liberties. And let's consider other ways that the state deals with fraud. In the context of proceeds of crime, which is essentially fraud, the prosecution is required under the Proceeds of Crime Act 2002 to apply to the court for confiscation orders or account freezing orders. Prosecutors are not permitted, for all the right reasons, to simply go into a person's account and take money directly with no judicial authorisation. Similarly, attachment of earnings orders, which are similar to deduction of earnings orders, means a person may apply for the court to require a person's employer to make payments to them directly from their pay. The only difference is that these orders are made by an independent court. But this bill proposes to allow a minister, whose role by its very nature is not independent but involved in politics, to make these orders. So the status quo provides judicial authorisation where there's been wrongdoing, whereas these parts of the bill neither requires judicial authorisation or, in many instances, proof of wrongdoing. I'm sure that the Minister will use expedition as the reason for no judicial authorisation in the bill. You want to recover debts as quickly as possible, and the courts are just so slow, we keep hearing. But wouldn't it also be expeditious to reclaim monies in the context of those other framework examples that I've used? Yet those orders are only made by a court on application. Why is that? Because it allows an independent court to consider all the circumstances of the case. And that is important, as it could be that an overpayment in this instance is made due to an error of the state. And just to remind ourselves that alarmingly, statistics show that 70% of appeals against DWP PIP decisions were upheld, highlighting systemic flaws that judicial scrutiny could detect and correct. Whether the county court or the magistrate court is the right place could be explored further. But to note, I know that these amendments, if moved at report, would trigger hundreds of consequential amendments to ensure proper judicial authorisation. But I agreed with the Bills Office not to table all of these consequential amendments at this stage so as not to clog up the marshalled list. But what that inadvertently revealed were just how many instances in this bill ministers are afforded to avoid judicial authorisation. Let me ask each of us all here today, would we be happy for the government to access our bank accounts without notice, without judicial authorisation and without suspicion of wrongdoing, merely because we received a payment from the state? And if not, why should we expect it of others? It's worth considering at this stage how these orders will be triggered as well. As with other aspects of the bill, it will be based on algorithms indicating when a person's account goes above a certain threshold, triggering an automated system where account information from banks will be required and money can be taken away. I will be returning to the problem of algorithms in another group, but for now, two things to reflect on here. What if someone receives a gift of money deposited in their bank account? What if someone hasn't spent as much as usual in a particular month? Are we seriously saying someone who's been given, I don't know, £50 for their birthday or has been thrifty, meaning an extra few pounds in their account, could trigger the mechanism in the bill, suggesting they must be doing something dodgy? And suddenly the Minister is able to see their account information. But it also seems that yet once more, this is all about low-hanging fruit. Sophisticated fraudsters and organised criminals, who we can be sure are keeping a very close eye on this committee and on this bill, are simply likely to use multiple accounts to keep their amounts under the thresholds or use overseas accounts, thereby rendering the provision of the bill useless apart from punishing the most vulnerable for inadvertently breaching new bank rules. Finally, I can't see how this bill won't end up leading to all sorts of litigation. It's worth noting that in the Netherlands, the government introduced the System Risk Indication, an algorithmic tool designed to detect welfare fraud by analysing data from various sources. Proceedings were brought in the Hague District Court, which found in the NJCM versus the Netherlands in 2020 that the measures were a breach of Article 8 of the ECHR. France and Denmark have also introduced similar measures, which are currently subject to litigation. The measures we are discussing here today go much further. And so, my Lord, all these amendments seek to do is to reduce that sort of risk of lawfare and also provide appropriate oversight. The amendments do not eliminate the power to order a bank to supply information. They retain the state's right to make the respective orders. Payment will still be made to the Minister. They don't alter the civil penalties also available under the bill, but they simply seek to temper constitutional concerns about proportionate treatment of state action and appropriate judicial scrutiny to ensure that everyone is treated fairly before the law. So I do hope that the Minister will agree to look at these modest amendments, seriously, modest amendments, but I think with serious intent to make the bill fairer.
Amendment proposed, clause 17, page 10, line 19, leave out make and insert apply to the appropriate court form.